at the back. Welcome, a very warm welcome to the second annual Ngara Institute Ralph Summy Annual Lecture and this Australian Activist of the Year Award. Thanks also to the Mullen Folk Quartet for entertaining us there for a little while. First of all, I'd like to acknowledge the traditional custodians of this land, the Bundjalung people, and we offer our deep respect to the elders past, present and future for their knowledge on how to live in productive harmony with this ancient land over the last 65,000 years at least. Perhaps as well as a Bill of Rights tonight that Gillian is so kindly going to inform us about, we might also need a treaty with the traditional custodians of this land. Our annual lecture is named after a retired professor, Ralph Summy, whose portrait is just around the corner there. And he taught political science at the University of Queensland for 33 years and established a degree in peace and conflict studies. So he was one of the inspirations of our politics in the pub. So with no further ado, I have the great honour of inviting Gillian Triggs to come to the stage and give us our annual lecture. Thank you, Gillian.
Well, thank you for that wonderful, warm welcome to Mullumbimby. I'm enormously honoured to be here, to be on Bundjalung land. I acknowledge the traditional owners of the land and respect the elders, and I do hope there are some here this evening. I've been here now for more than 24 hours, and I've been a tourist in the area. We've been to Margaret Ollie's house and seen the art. I've shopped in the local main street. I nearly succumbed to buying some hippie clothes, but ultimately stayed with the boring old jacket and the black dress. But I've had a wonderful time, and I've learnt an enormous amount about Mullumbimby just in the last 24 hours. One is that you don't say Mullumbimby, you say Mullum. That I'll get right the next time I come. But also, this is, of course, a wonderful privilege to be here for the Ngara Institute. But it is also something of a nostalgic visit for me in the sense that you remind me so much of being a hippie in the 60s. I wore the flares and the silk scarves around my very long hair and the beads, and I believed in making love, not war, and I still believe in making love, not war. And I think you do too. It was all a bit pretentious in those days. I remember we would talk about Jean-Paul Sartre and Kierkegaard and mainland China because we thought we were very sophisticated, and we had candles in Chianti bottles and we talked about all sorts of important things. We hadn't the slightest idea what we were talking about, but we knew we were against the Vietnam War. That was clear. So I was very pleased to read about Ngara. It is a very important institute, and I totally support its objectives. I understand the word Ngara is from the Darung language, and you have permission to use it, and it means to listen, to hear, and to think. And I can think of no better words to describe what I think we need so desperately in contemporary Australian society. When I was a hippie, I was at university, I was in the moratorium marches behind Jim Cairns in Swanston Street in Melbourne. For a young girl, it was a gesture, and it was a powerful one for me because I've never forgotten that experience. But that world in the 60s was a world of such opportunism, of opportunity, of optimism, and of hope, especially for women. I had a free legal education, I had a free master's degree, and a free PhD. We haven't done that for our young people today. We leave them with huge debt. What I want to speak to you about tonight really does reflect my observations, not only over the last 5 years as President of the Australian Human Rights Commission, but really coming from those days of the 60s when there was so much hope and belief that through the rule of law, we could achieve the values for which Australians and our forebears had actually fought. And we believed in it, we believed it was possible, and we believed we were going to do it. Sadly, I think we have not achieved it. I believe that in many ways we've been regressive in relation to human rights in the last few years, and I've come to the very strong view now that as a nation we need, as a matter of urgency, to look at some form of legislated charter of rights to protect our fundamental common law freedoms as ancient as the Magna Carta more than 800 years ago.
Yeah.
But also we need to meet the international human rights obligations that as a nation we were committed to and have been committed to by treaty for the last 70 years or so. So I'd like to explain this evening why we need a charter and why Australia has become isolated and exceptional in its approach to human rights implementation. We are the only democracy and the only common law country in the world that does not have some form of charter of rights in this country. It is astonishing, and the consequences of this are starting to show. So I want to talk about why the legal system, in my view, has failed Australians, especially the most vulnerable in our community, and why the rejection of human rights obligations, either as law, which I particularly emphasise, or moral and ethical responsibilities, threaten the fundamental rights of each of us. And how then, finally, will a charter provide a solution to strengthen the protections that underpin our democratic and multicultural community? Well, I'd like to begin with some very recent examples. And one is that I suspect in this audience you will be aware that 2 days ago the government passed 2 pieces of legislation in Canberra. One is the Foreign Influence Act, as it now is, and the other espionage legislation. And both of these pieces of legislation have been presented to the public in the limited time that we've had. We've only had the reports in relation to those bills for the last week. But in the limited time that it's been in the public arena, the government has argued that we need them because we don't like foreign interference in our elections and we want to get it through speedily because we have Super Saturday coming up on the 28th of July. I do not understand that connection, but I think it's all linked in this devious way with allegations in relation to the American elections. And I believe actually is designed to deny the right of many of us to advocate in the public arena. It's part of what has become, I think, a war on civil society and a war on advocacy for basic fairness, for social justice and for the rule of law. It might seem at one level that of course we don't want foreign interference and of course we don't like spies and we're going to set up a registry system to make sure that they're all registered before they do have any engagement in Australian politics. At one level, okay, well all right, that sounds reasonable enough, but when you read the legislation, and very few Australians will have done so, in that legislation there are extraordinarily broad provisions which criminalise the publication of information, including opinions and reports or conversations, that are deemed in the government's mind, the minds of discretions of ministers, that they would affect Australia's political, military or economic relations with any other country. Now, the difficulty is that this is such a broad notion that it may very well affect, for example, the Fairfax newspaper that released the story recently about possible war crimes by Australian forces in Afghanistan. The difficulty is that this kind of legislation that prohibits public sharing of information, it prohibits protesting, it prohibits advocacy, is deeply damaging to the Australian public. But by an overreach of legislative reform, the government does it by saying, well, we have a national threat of foreign interference, with not so subtle implications that we don't like Chinese investors putting up the property prices in Sydney. But it's reflected in other legislation, for example in New South Wales, that prohibit protests on Crown land, particularly, as you all know in this district, against coal mining and fracking. Interestingly, the Australian High Court, in the Tasmanian case of protesting by Bob Brown and others, has been declared unconstitutional by the Australian High Court, and it may very well be that if challenged, so too will the New South Wales legislation. But I mentioned the Foreign Influence Law and the Espionage Offences Act by way of example that simply to share information deemed by the government to be in a way that might diminish economic, military or political relations with another country will be and could be interpreted in ways that yet again diminish the capacity of the community to speak freely, to share information and to expose wrongdoing. Now you might say, well, let's not get too aerated about this, let's not be too agitated about it, it may never happen, and we've got sensible directors of public prosecutions and lots of lawyers who can protect anybody ever prosecuted with all of this. So let's not overreact to it. Let's constrain or use our political capital carefully. But you might have noticed that also 2 days ago, on the 28th of June, a former Attorney General of the Australian Capital Territory, Mr. Collery, has now been prosecuted under Section 39 of the Intelligence Services Act on the grounds that he gave information to ABC reporters that had been leaked to him by an employee of the Australian Security and Intelligence Services. Now, he in essence was a whistleblower. He was concerned about one very important issue, and ironic in light of the legislation we also passed 2 days ago, and that is that Australia had been spying on the cabinet of East Timor for the purposes of ensuring that we had an advantage in our negotiations over the Timor Gap Treaty discussions. Now, he is being prosecuted criminally for an offence that today attracts a 10-year criminal sentence, but fortunately for him, at the time at which he allegedly committed the act, attracts only a 2-year sentence. But my point in raising these very contemporary questions is to say that they are examples of legislation that is being introduced by Canberra that is complex, that can sway public opinion as being necessary because it's a threat to the national interest. When the Prime Minister says we live in dangerous times, that's almost an unarguable proposition. Very difficult to contest. We don't know what evidence ASIO has. Do we trust ASIO when they say, we can't tell you what information we have, we just need this legislation? And I'd suggest that good governance requires transparency and accountability. We need the information, and then as intelligent adults we can say, yes, we'll go along with some form of this legislation, but not legislation that is so wide. Now, I give those examples merely to get myself into trying to explain to you why I think in Australia we've got to the parlous position where I believe we now need a Charter of Rights which will allow the courts to hold government to account for legislation which fails to accord us the common law principles that have been underpinning our Westminster democratic system. But let's go back a little bit in history. And there may be many of you in this room as old as me, but you'll remember that rather irascible, brilliant, demanding lawyer, Dr. H.V. Emmett. You know that he went at the end towards the end of the Second World War to Washington, to Dumbarton Oaks, as Australia's representative to negotiate that visionary document, the Charter of Human Rights, the Charter of the United Nations. And critical to that document, if you go back and have a look at it, it's a very simple and quite inspiring document in 1945. What it did was to link human rights violations with conflict. In other words, when you breach people's human rights, that is almost inevitably a precursor, ultimately, to conflict, to persecution, to discrimination, and ultimately to the plight of the 65 million people the United Nations now estimates are fleeing their breaches of those rights globally. He was very effective. He had a vision. He tried, for example, to stop the veto votes of the 5 what became the nuclear weapon states. He was unsuccessful, but he had a vision. And 3 years later, he was asked back by Eleanor Roosevelt, as a very small group of men, they were all men, to negotiate the Universal Declaration of Human Rights. That passed the General Assembly in 1948 without a single negative vote under his presidency of the General Assembly. A remarkable achievement by an Australian who was readily acknowledged in that environment as having a great contribution to make and a great legal mind to bring to the visionary view of the world that we wanted to see at the end of that World War and the horrors of the of the Holocaust, and of course the end of that war with atomic weapons. Well, that was a great basis for Australia, because from then on until the late 90s, Australia was genuinely a good international citizen, and we were deeply involved as a prime mover in negotiating some of the great international human rights treaties: the International Covenant on Civil and Political Rights, Convention on the Rights of the Child, the Genocide Convention, of course the Refugee Convention, and so on, right up until 1996, with the International Criminal Court established to try individuals for their individual responsibilities for breaches of human rights. But then we came to 2001, and I know that perhaps the historians in the audience will always have trouble with anybody putting a line in history. It's a difficult thing to do, but if you were to do it in relation to assessing the compliance with human rights in Australia, I think you might place it in the year 2001, because it was a very important year. That was the year that we had the government lying to the public about asylum seekers, predominantly of the Islamic faith, throwing their children overboard in order to ensure that they were rescued by Australian Coast Guard and officials. Months later, the Senate determined that there was not a scintilla of evidence to justify that allegation. But you may remember that that led to an unexpected Howard victory in government some weeks later. Now, this is perhaps the beginning of this post-truth world that we live in. It doesn't matter if you lie, if you get the political outcome, because it's not exposed till months later, and by then it's past history. And that, I think, is something that we have allowed to have happen over the last 2 decades, and we now see it in particular form in the United States, but we also, of course, here in Australia. But the same year, of course, was Tampa, when that Norwegian captain brought the Tampa with asylum seekers rescued on the high sea into the territorial seas of Victoria, of Australia, within Australian jurisdiction, and into the arms of Justice North of the Federal Court, who said, in essence, we have a refugee convention, we are bound by that convention, and we are bound to accord these people the respect, and at least to accord them the dignity of considering whether their claim to asylum is a valid one or not. And you know the rest of that history. But within weeks of the Tampa, we had 9/11, the attacks on Twin Towers and Pentagon. And what I think has happened in Australia is that from that year, we've seen a conflation of asylum seekers arriving with people smugglers and boats smashing up against the rocks, allegations of throwing children overboard, mixed up with fears of terrorism and a fear of a different religion than most Australians. And from that year, I think we've seen an extraordinary decline in democracy and in protection and respect for human rights in a way that I think I would have found astonishing in the early days of the 60s when I was a law student in Melbourne. We have failed to protect fundamental freedoms. We no longer comply with many of our international human rights obligations, and indeed we have passed laws which explicitly deny those obligations. Unlike every other democracy, as I say, we have no Bill of Rights, and Australians no longer speak the language of human rights, as we are isolated from the common law and jurisprudence of comparable nations such as the United Kingdom, much of Europe, North America, and even our neighbour across the Tasman, New Zealand. The courts struggle to find the legal tools to comply with the common law principles of legality. Parliaments, most worryingly, have failed in their traditional role of restraining the executive, restraining government for an overreach of power. And we have failed to deny and to safeguard and protect the people against an overreach of executive discretion by ministers, most particularly this extraordinary creation of the Ministry of Home Affairs, the super ministry, under a minister who appears to have no moral or legal scruples whatsoever. The various forms of media today, and social media in particular, are swamped by fake news, by post-truth, and by so-called alternative facts. You'll all remember that extraordinary story of the White House press secretary who announced that the president's inauguration was attended by the largest number of people ever in the entire history of the human race. This was objectively untrue. But in defence of the press secretary, Kellyanne Connolly defended the press secretary and said he was simply providing an alternative fact. There is no such thing as an alternative fact. There may be alternative facts, there may be things that change your mind, but there's no such thing objectively as an alternative fact. But that's the world we're in, and a growing tolerance for views that are not backed by expert evidence, by data and by law. The very principles on which I grew up at university. Science was a god in the 60s. If you studied science, you understood science, and you measured things by reference to science and data, then you were pretty sure you were on good grounds. Today, we dismiss the Finkel inquiry on climate change, a perfectly rational, data-based, evidence-based inquiry. We dismiss it, really, without further discussion. Well, what does all this mean? What does it mean in practice? Because these are grand ideas. Well, a few years ago, the Attorney General, George Brandis, a close friend of mine, asked the Australian Law Reform Commission to identify those Commonwealth laws that encroached upon traditional rights, freedoms and privileges. And I was getting really quite excited at this. I thought, this is wonderful. What he did in this reference to the Australian Human Rights Commission was specifically to exclude the right not to be detained arbitrarily without charge or trial by your peers. In other words, you could look at any other freedom, but you could not examine the indefinite mandatory detention of asylum seekers in Australia. And yet I think for most Australians, they all thought this was a wonderful idea. The attorney was wonderful. He was raising these questions of human rights. But nonetheless, the Human Rights Commission went on and they identified 121 laws that included all sorts of things: freedom of speech, the reversal of the burden of proof in criminal law, the creation of strict liability, procedural fairness and due process threatened by mandatory cancellation of visas on character grounds, or the fast-track process denying refugee status. The attempt through freedom of speech, restrictions on freedom of speech, the government silencing whistleblowers with a threat of 2-year prison sentences if they talk about conditions in offshore and onshore detention. That has now mercifully been repealed. But perhaps particularly an observation that we have had an unprecedented level of growth in executive discretionary making powers as a consequence of legislation. That is not subject to, we can't force the minister to make a decision, and we cannot review the accuracy at law of that decision, except in some very unusual and exceptional cases. We have disproportionate and repressive counter-terrorism laws that allow the detention of people without charge or trial for questioning for up to about 2-3 weeks, and it's extended frequently. We have preventive detention orders for 14-year-olds. We have indefinite detention for violent criminals once they've served their sentences, including in many, many cases we found at the Human Rights Commission, those with mental illness being held in maximum security prisons who were never tried but were found to be unfit to plead. We have draconian bikie laws. Always worried me a bit because my son's a bit of a bikie, and I had visions of me being reported in the front pages of the Australian rescuing James from a Queensland prison for associating with the Queensland bikie law. We have data retention laws and privacy invasions. We now have facial recognition technologies, all of which will assist the government in promoting its argument that it must defend national security and must defend our borders. They get away with anything by arguing fear and arguing that it's necessary without ever producing a database or evidence for these laws. Maybe we need them, but we don't know why we need them because the evidence is not produced to us. We have growing homelessness, domestic violence, elder abuse, are serious and underfunded social issues that are not being attended to. We've been unable to agree upon Indigenous recognition constitutionally, and we rejected the Uluru Statement from the Heart without any discussion in the public arena at all. A disgraceful, truly disgraceful phenomenon. 100% of those held in juvenile detention in the Northern Territory are Indigenous. Across the country, 55% are Indigenous, and in terms of adult prisons, at least 25% are. Indigenous children have 10 times greater likelihood of being removed from their parents into out-of-home care than a non-Indigenous child. We are moving towards a second generation of stolen children. I believe that we need to recognise their rights of consultation, of family support, to try to resolve these problems locally and within the family, rather than taking children away, at least in many cases. But in summary, my concern is that we do have a deep crisis in contemporary democracy, with a lack of faith in our institutions, threatened by corruption and abuse, amplified in the Royal Commission into the banks and financial advice, the business and corporate world where taxes are avoided, yet they call for further tax deductions. We have the police in Victoria faking breath tests to meet quotas. We have political representatives in Parliament who clearly can't read the Constitution, and the dual citizenship debate. And we have the demonisation of welfare recipients, and particularly of women charged with double dipping for maternity leave. In summary, my concern is that all of these breaches of the common law, and one could speak about them at great length, are a threat to all of us, because they threaten the underpinnings of our contemporary democracy. And let me give you an example of what it is that a Charter of Rights could do if we were to think positively about how we take this country from what I believe is a dark place to return to the values that many of us grew up with in the earlier decades. And one is a decision by the Papua New Guinea Supreme Court in 2016. It was a unanimous decision of the Papua New Guinea Court, and some of you will remember that they were quite exciting days in 1975 when Papua New Guinea received its independence. And when it did so, it got a modern constitution. And in that constitution is a very important provision: no person shall be deprived of his personal liberty. Well, the men on Manus Island, and there are still about 600 men on Manus who've been there at minimum 4 years, some of them many more years, they challenged their detention by the Papua New Guinea government at the request and expense of the Australian government. And they argued that they were detained indefinitely without access to a durable solution and permanent settlement, without being charged with any offence and never having a day in court. No judge had ever been able to rule on their indefinite detention. Well, the Papua New Guinea Supreme Court said that it was the joint efforts of the Australian and Papua New Guinea governments that has seen asylum seekers brought into this country and kept against their will. These arrangements are outside the constitutional framework of Papua New Guinea. They are entitled to the benefit of the constitutional provision that no person shall be deprived of his personal liberty. And on that basis, the Papua New Guinea court ordered the Prime Minister, O'Neill, to close the detention centres in October last year, which he did. The Australian government then transferred those remaining detainees to partially finished new detention facilities somewhere else on the island that were renamed a facility that wasn't described as a detention facility. Ultimately, little was achieved for those asylum seekers, and many, as you may know, preferred to stay in the detention centre where they felt safer than in the local community. But the point that I really want to make by raising that Papua New Guinea decision is to say they had a constitutional provision that said you have a right to liberty. Now, there's nothing new. This is not an invention of the left-wing United Nations. It's not an academic construct. It was right in the middle of the Magna Carta 800 years, or more than 800 years ago, in 2015. And you'll remember that bad King John was forced to put his seal on the Magna Carta. He couldn't read, he couldn't write, but he could put a seal on it, forced by his feudal barons to agree, along with things like the breadth of a piece of cloth and the content of a glass of wine and the feudal duties to your lords, was this incredibly important provision. No man may be detained arbitrarily without charge or trial by his peers. This is a core feature of our democracy, of our parliamentary representative system, and of the common law and the freedoms that every person in Australia has. And it was reflected in this modern constitution. But let us contrast this with the M68 case in Australia. This was a sad case of a Bangladeshi woman. She'd been, you're very familiar with this, she was an asylum seeker intercepted at sea and detained on Christmas Island as an unlawful non-citizen. Her claim to asylum seeker was not assessed, and she was taken ultimately to Nauru. And she, mercifully, had been pregnant and was allowed to come to Brisbane for reasons of medical complications, to have a baby in Brisbane. And she challenged the authority of the Australian government to return her to Nauru and to those conditions described by the United Nations Rapporteur on Torture to be cruel and inhumane treatment. She challenged it, and the Australian government officials in Canberra started to look at the Migration Act to say, well, what is the authority for our officials to send her back to Nauru? And it dawned on them that there was nothing in the Migration Act that allowed them to send her back to Nauru. So what they did, with the compliance and complicity of the opposition party, so it's the Coalition and the Labour Party, agreed to an amendment to the Migration Act, section 198AHA2, which required the official to deport back to Nauru, and it was retrospective to cover the exact dates of the period of our Bangladeshi asylum seeker. So that went through Parliament in the blink of an eye. I don't think any Australian was remotely aware of this legislation, so that by the time it got to the High Court, the Migration Act had been amended. Well, 6 judges of the High Court of Australia said, well, up until that amendment, the Migration Act did not permit her return to Nauru. But the retrospective legislation rushed through before it got to us, fills the gap, amends the defect in the Migration Act, and the legislation now requires the official to deport her to Nauru. We had one dissenting judge, Justice Michelle Gordon, a relatively recent appointment to the High Court, and she said, no, we have a principle of the separation of judicial powers, and only the courts can impose penalties. And to send her back to Nauru in those conditions is a penalty and is not a privilege of the executive government. We have a separation of powers. The courts are there to impose penalties if one is to be imposed. And she said this law is a breach of the separation of powers. Now, the tragedy, of course, is that she was a minority judge, but the difficulty and the point, again, I'm speaking about this case, is that by way of contrast with Papua New Guinea, which has in essence provisions that protect human rights, we did not have that provision. We have nothing like the Magna Carta provision that no man may be detained arbitrarily without charge or trial by his peers. And this court was prepared to say, if Parliament has spoken and made clear, then the provisions of the Migration Act apply, and we don't mind that it's retrospective. That's fine. Now, for me, I believe that retrospective legislation that imposed a criminal prosecution of a penalty was a breach of the doctrine of the separation of powers, but it's a minority view. But my key point is that had we a charter, had we Bill of Rights provisions, we could have come somewhere close to the kind of decision that was made by the Papua New Guinea court. And I am deeply worried about and I ask the question, how far can Parliament go with its legislation before the courts will step in to insist on the principles of legality and the common law? Now, one argument is, well, that's not the role of judges. They're there to apply the law, and if Parliament, through our parliamentary representatives, have enacted a law, that's sacrosanct. It's Parliament, it's the voice of the people. That sounds perfectly reasonable. My view is that if both the major party and the opposition party collude on a law which breaches fundamental principles, then the courts must step in and protect basic rights. And it was mentioned earlier tonight that the principle of terra nullius. We had that principle for 150 years, a very, very long time, since the Mirror-Perham decision in the Northern Territory by Justice Blackburn. All the evidence pointed to the falsity of that determination, but it remained Australian law. But it took the Brennan Court to say, well, just a minute, that's not the fact, and the law is wrong. Australia was not empty, it was not terra nullius. We will say as a court that this is wrong. They overturned the law in the Mabo No. 2, and you all know what flowed as a consequence. In other words, some courts have been prepared to say we must protect these fundamental rights of people. And it was a very important decision. Well, my question then is, how did we get ourselves into this position? And I don't want to put too gloomy a picture. There are some rays of light. We do have some judges prepared to find a duty of care in tort law. I can come back to that, but it's rare, very rare, and I can give you a couple of examples of that. But my key question then is, how did we get ourselves into this mess? Why are we so different from the United States, from New Zealand, from Canada, from the United Kingdom, from Germany and France, all of which states have a charter or Bill of Rights, and all of which would hold illegal the mandatory detention of asylum seekers and refugees without charge or trial? How did we find ourselves in this position? Well, one critical point to make is that all of those treaties that I mentioned at the beginning is stimulated in part by the vision of Dr. H.B. Evatt. Most of those treaties have not been implemented into Australian law. So the International Covenant on Civil and Political Rights, the Refugees Convention, the Convention on the Rights of the Child, these treaties and many others have never been given the legislative imprimatur from Parliament. Parliament has refused to create those as directly enforceable rights in Australian law. We also live in the only region of the world that doesn't have a regional convention on human rights. Africa does, Latin America does, of course Europe does. We don't. So we don't have that agreed sense of what the rule of law means, what the principle of illegality means. But now moving the next step, what about the Constitution? What about the Australian Constitution? Well, I don't know whether you've read recently the Australian Constitution, but it's a bit boring. It's basically about state and territory rights. It's a very practical document, and it's served us well in terms of managing federalism. But you'll find very, very few mentions in the Australian Constitution of fundamental rights. And you might be surprised to know there's nothing in the Constitution that expressly gives you a right to vote. The High Court of Australia has implied a right to vote because we have a representative democratic system, and that by necessary implication means you've got a right to vote. But that's only because the High Court said so, not the Constitution. Do we have a right to freedom of speech in the Constitution? Absolutely not. There's nothing in the Constitution about that, but the High Court again has implied a right of political communication. It's not quite the same as the right to freedom of speech, which exists in the common law, but it's not in our Constitution. We have a no right to trial by jury in the Constitution. We have a right to review ministerial decisions that are wrong in law. We have no contemporary provisions prohibiting slavery. We have no rights that protect the right to freedom of movement or the freedom of protest, which is very much in the news in New South Wales at the moment. There's no right in the Constitution to do any of these things. There's no right to freedom of association for the unions or for any other association that we care to develop. These rights, if you asked an Australian in the street, do we have a right to freedom of speech, do we have a right to freedom of association, they'll say, yeah, well, of course we do. And we do, in fact, for practical purposes, but they're not in the Constitution. We have a very limited Constitution that has, in some respects, been amplified by the views of the Australian High Court in two cases, the right to political communication and the right to vote, only achieved negatively because they said prisons have a right to vote, and therefore by implication the rest of us do. But it's an extraordinarily negative and weird way of getting around to what rights we have. We also have provisions in our Constitution that are quite extraordinary. Section 51(26), known as the race power. That is, that the government's got the power to make laws with respect to people of any race for whom it's deemed necessary to make special laws. Well, nobody thought that was ever going to be particularly important, but some of you might remember the High Marsh Island case, which concerned the rights of the Nurrinjeri people as custodians of secret women's business. The court was left open the possibility, the extraordinary possibility, that the government could pass laws that were negative to Indigenous Australians, and the court refused to deny that that was possible. Well, as an academic at that time, I thought we would never have a government that would pass laws that were negative to our own Aboriginal and Torres Strait Islanders. Well, I was wrong. 12 years ago, the Australian government passed the Northern Territory Intervention. which was in effect a form of military intervention into the Northern Territory, and in order to do it, they had to suspend one of a few international human rights treaties that is part of domestic law, that is the Racial Discrimination Act.
Wow.
I think Australians who are aware of this were appalled. The Racial Discrimination Act has since been reinstated for the Northern Territory, but the measures against Indigenous peoples have been retained on the basis that they are special measures for the advancement of Indigenous peoples, like the welfare card, like the special conditions on the 73 Indigenous communities that still suffer under this law. Now, I say suffer because they say they suffer. It's not for me to say, well, it'll do you good, it's going to help. They don't want it, and what they want is consultation. And that's what they asked for in the Uluru Statement from the Heart. They simply asked for a right of consultation and a right to advise. And in my job as President of the Commission, and briefly, or for 8 months or so, as the Aboriginal Torres Strait Islander Commissioner, the one thing, wherever I went through Aboriginal communities, the one thing that people all said to me is, yes, we can agree to a welfare card. Yes, we can agree to our children being taken away if they're in dangerous circumstances. Yes, we can agree to no alcohol and drugs. But we want to make that decision in our community. If we own that decision, we will abide by it. But we will not have it imposed on us in a way that's undignified and respects our integrity and our sovereignty. Well, that's the Constitution. All right, well, let's not get too excited. Before I say that, I should remember that the Tasmanian protest laws have been declared unconstitutional by the High Court, so the High Court does do some good things sometimes. I'm not presenting a totally black picture. But the Constitution has not been very helpful, and it certainly hasn't helped asylum seekers and refugees, and is very unlikely to be able to help too many of those under disproportionate laws and extreme overreach executive discretions in counter-terrorism and some aspects of civil dispute and civil protest. But then we come to the role of Parliament. Well, what about Parliament? In Australia we could say, all right, we didn't have anything in the Constitution, we haven't got a regional human rights convention, and we don't have a Bill of Rights. We don't need one. We've got Parliament. We trust our politicians. We vote for them. They represent our views. Their word is what we most respect. Well, we could say they are uniquely positioned to protect our common law rights, and historically, parliaments in England and in Australia have exercised what's called legislative restraint. Parliaments are presumed to act in compliance with our common law freedoms and in conformity with our international obligations that Doc Evatt and others signed us up to. That no longer applies in Parliament. And the one committee that's been set up, it's the so-called Scrutiny Committee for Human Rights, has proved to be a failure. I was very excited when the Gillard government brought this Scrutiny Committee into existence in Canberra, and I'm a great fan of Le Carré spy novels. And I wrote an academic article that was published calling Australia's Human Rights Coming In From the Cold. Well, I was wrong. We didn't come in from the cold. The chair of that committee is Philip Ruddock, and the committee barely understands human rights, barely understands the treaties, and breaks down now, and has done for some years, down party lines. So instead of a reasoned understanding of the extent to which proposed legislation, including the 2 bills that passed 2 days ago, is absent from that committee, and the reports they issue reflect the ideological positions of the parties. Now that, I think, is an extremely disappointing position if you were going to say, well, let's put our trust in Parliament, let's say they're our representatives, and we will rely on them to ensure that they do not pass laws that breach our fundamental freedoms. That, I'm afraid, is failing, and Parliament is failing, and I'm particularly troubled when we have the government of the day with the opposition party colluding together to pass the legislation. And that is what happened 2 days ago. The Labor Party has agreed in a committee form with the government that these 2 forms of legislation adequately protect our rights. Now, in the last couple of days, you'll see quite a lot of groups in civil society saying they do not protect our rights, they are too broad, and we don't know how they're going to be applied in practice, simply because we have used information in the public arena to advocate for a better position. So I think it's extremely worrying. So Parliament hasn't been successful. What about the courts? Well, it's been very disappointing to me as a lawyer that the courts have not, in recent years, stood up for these principles. Now, we can go back to the Brennan Court, and I've mentioned that in the Mabo case and the end of terra nullius. We had the Mason Court, a very fine Chief Justice, looking at all sorts of issues like the case that concerned children's rights and saying that government officials should at least take account of the Convention on the Rights of the Child, and that there's a legitimate expectation that our government officials will be aware of our international legal obligations. If you read a High Court decision now, and for the last 10 years, they won't even mention an international human rights treaty to which we are party. It's very, very rare. And in the major decision I mentioned to you, the M68 case, not a single judge, even the dissenting judge, mentioned our international obligations. Well, why do the courts not stand up for those common law principles? They do it on the basis of this principle of parliamentary sovereignty. If Parliament has spoken accurately and unambiguously, the courts won't interfere. They'll say, if the legislation is clear, and the Migration Act is nothing if not clear, it's been amended so many times to capture every single gap in the law, that is very, very clear law. And therefore, the courts will not be able to override the law as set out by Parliament. Well, in short then, I'm very disappointed by the failure of our legal system, and that we've become rather isolated from the jurisprudence and the law of most of the countries that we choose to compare ourselves with. So what do? I'd like to see a way forward. At the Commission, we published, I think, a helpful document, Pathways to Protection. There are ways of protecting our national borders while also acting in a humane way to asylum seekers and refugees that seek our support. It's not a binary. If you listen to many government ministers, they will say, if you do one, if you want to save borders, we've got to hold 120 or 30 children on Nauru. We've got to hold 600 men on Nannas, 300 on Christmas Island, and 1,300 in Australian mainland detention centres. That is a binary which is a false binary. It's misinformed, it's misleading, it's deliberately misleading, and it's based on fear that has been exaggerated. So where do I end up with this observation? And I perhaps should point out that I'm not a human rights lawyer by training. I'm an international lawyer. I've worked in the commercial and international areas, but I would never have said I was a specialist in this area of law. But it's in the 5 years as president of the Human Rights Committee I started to understand that these were much more than abstract legal problems that one could observe and teach and practice, but they were affecting the lives of thousands, tens of thousands of people over these last few years. And as president, I really learnt that when I went to Christmas Island 3 times, to every detention centre several times in the 5 years that I was president. And I'm sure you all understand that when you are sitting talking to an asylum seeker who has simply sought a refuge from persecution, discrimination, from conflict, from poverty, you look into their eyes and you talk to them, you can't say, well, thank you for that, I'll add you to my database, I'll report to Parliament, and there's nothing I can do for you. You cannot do that. I think those memories for me of talking to those people will remain with me for the rest of my professional life. So the solution for the future, I do believe now, is a Charter of Rights. Now, I'm not talking about a constitutionally entrenched Charter of Rights. That would be ideal, but even I, as a supreme optimist, do not believe we're going to get a constitutional change. We can't get constitutional change to recognise our Indigenous peoples. I don't, and I see that, frankly, as a priority. If we were to argue for constitutional change, personally, that is what I think is the most important thing. I don't argue for a constitutional Charter of Rights. What I ask for is a piece of legislation that could be amended the following year, but they never are in practice. New Zealand's had one for more than 20 years, 25 years. They've fiddled around the edges with bits of it. So has Britain, so has Canada, but they've never repealed them, and they've not substantially amended them. But you can do that with a legislated Charter of Rights. But what I say is, if we had a simple document, we could draft it tonight. We could set up a drafting committee at Mullumbimby and have the Mullumbimby Charter for Human Rights. It wouldn't take long. we could do it. Simple things: a right to freedom of association, a right to privacy, a right not to be detained without charge or trial. We could do this very simply. That would build a bridge to trust, that the judges were not going to be activist judges and get completely out of control, and I don't believe for a minute they ever would. They're very conservative in the main, and mercifully so. We have very high caliber judges in Australia, and I'm grateful for that. We're not going to turn them into raging hippie lefties. We're not going to do that. They are going to act according to the rule of law, as indeed they should. But if we had the standards, it would mean that we could hold the government to account more clearly, and we could appeal to the courts directly for the enforcement of those rights. And the model is called a dialogue model, and Victoria has one, and the Australian Capital Territory has one, so that the matter goes to a court. If it's in breach of the fundamental provision of the Charter, the court doesn't say, we thereby declare the legislation to be invalid. What they do is they send it back to Parliament and to say, you change this law to comply with the Charter of Rights. So the sovereignty of Parliament is maintained, and on the very few occasions on which this has occurred, Parliament has complied. And you might know there's been a very recent example of this in Victoria. Victoria was holding juveniles in maximum security adult prisons in Barwon. This is illegal under the Convention on the Rights of the Child. If I complained about this, I would be told, very interesting, Gillian, nice point, but the Convention on the Rights of the Child is not directly part of Australian law. And we made that argument in Western Australia and failed. The court said, Convention's not part of Australian law. If we want to hold juveniles in adult facilities, we will do so. In Victoria, it went to the Supreme Court, and the Supreme Court said, no, the rights of the child are protected in our Charter of Rights, and therefore those children and juveniles must be brought to a specially designed juvenile facility in Parkville in Melbourne. Now that's a small example, but if we had a charter of that kind with those basic rights in it, it would be possible for the courts to challenge and declare incompatible legislation that Parliament has passed. And the effect is much more widespread than simply the courts. In Victoria, only 1.6% of cases ever even mention the Charter. In England, 2% of cases. In Tasmania, in New Zealand, once in 23 or 24 years. So it doesn't happen very often, but what it does is, by having a charter, it means that government officials and legislators are acutely aware when they're drafting the legislation or adopting policies or making decisions that they have to comply with the Charter. It's educative, it's informative, it informs public decision making, so that the good is done much earlier in the system, and only in a very few number of cases do you ever have to go to a court to get a final judgment. Well, for all of those reasons, then, I say that it's time in Australia for us to look at a charter. We have done it in the past. Some of you might remember Father Frank Brennan's survey around the whole of Australia, and he reported to the government that there was overwhelming support in Australia for a Charter of Rights. The Labor government accepted that report and made moves towards establishing a charter, and then balked at the hurdle, and we didn't get a charter, and we got instead the Parliamentary Scrutiny Committee, which, as I say, has basically been a failure. I'm not a political person, but I now believe that if we are ever to have a charter, it really is something that a change of government will be required. I understand that it's not for me to talk about changes of government. I'm not really even interested in those questions so much as the outcome. What is it governments do for us that comply with those fundamental principles? And I do believe that the Labor Party has been looking at the possibility of a charter were it to win the election. I don't know whether they will or not, but we have a very interesting phenomenon of Queensland drafting the charter at the moment. Tasmania has made a political commitment to a Charter of Rights, and even the Northern Territory is investigating the drafting of a charter. It may oddly, curiously be that we get a charter, political pressure and will to do it at the state and territory level before we get it at the federal level. But I believe that as Australians, we now have an individual responsibility to stand up for a legal technique. It's not a solution to all of the problems by any means, but if we had the legal benchmarks, it will be possible for the courts to protect the interests. Now, I have just two very quick points to make before I finish. One is, and I did want to talk about a few of the more optimistic things. One is important. Australia's just signed OPCAT, the optional protocol to the Convention Against Torture, which allows international scrutiny of our detention facilities. That won't come into effect for another 3 years, but it's quite important. I know, you don't want to get too excited about it, but I feel like, in fairness, I should tell you. We have a seat on the Human Rights Council. I hope that proves to be effective. I don't know. The United States has withdrawn. Australia has stayed with it, and I'm pleased by that. We should encourage that. But there's also been a very, very interesting case. A federal court judge, just 2 or 3 months ago, received a petition from a pro bono litigation lawyer to allow a young boy, aged about 10, who was suicidal, and he'd been suicidal for a couple of years. The psychiatrists and the doctors had been pleading with the Department of Immigration and Peter Dutton to allow him, with his mother, to come to Australia to get proper medical treatment. He was in a profoundly distressed state. As you may know, in the report that I initiated as president, we found that a child in detention for more than a year was likely to be a 30% greater rate of either medium or serious mental deterioration compared to an Australian child in the community. The level of mental illness and distress and trauma of these children is documented by the medical profession, and we reported on it. It's very well known. And this particular child was in a very bad state. The Department of Immigration has resisted that child coming back to Australia, and they've resisted for the last 2 years. Right. Litigation lawyers got it to a federal court judge, and the federal court judge didn't look at anything that I've been talking to you about tonight. He said there is a duty of care in plain old ordinary tort law of negligence, that the Australian government is responsible for the care of these children, and sending them to Nauru, living in these dangerous conditions as defined by the United Nations for so many years, on average 2.5. Some of those children have been born and raised, they're now 4 and 5 on Nauru. Wow. Australia has a duty of care to those children, and having reached that decision in a court of law, he ordered Peter Dutton to allow the mother and child to be brought back to Australia for medical care. But what he did that was also quite exceptional was he said, I've checked the flight schedules of planes leaving Nauru, and there's a flight tomorrow morning, and I expect that mother and child to be on it. I think there are other ways of skinning the cat, in other words, than the ones I've been talking about. I'm talking about grand principles of human rights, of common law freedoms, the Magna Carta, restraints on executive discretion. We can appeal to other common law principles like the law of negligence, which actually got me there on that particular matter. But I'd like to finish by saying, in my job, it's been a difficult one, but humour really always does carry the day. And I remember going on my 3rd visit to Christmas Island, and I met a woman who was the mother of baby Feroz. Now, you might remember the baby Feroz case. When she arrived on a leaky boat, she was pregnant, and she was allowed to leave Christmas Island to have her baby in Brisbane. And mercifully, I mean, there is humanity in the system, I must admit, in some cases. But of course, they sent her back to Christmas Island. And she then applied to have her healthy baby son registered as an Australian-born citizen. But the Migration Act refuses to allow her to do that on the basis of a legal fiction, a deeming provision. Only lawyers talk about these things, but it's quite extraordinary. But anyway, there's a deeming provision that if he arrived in a pregnant woman, he is deemed to have entered Australia by sea. Well, if you can imagine that I'm in the heat of Christmas Island, I'm overwhelmingly hot in this really tragic island. She's in bright coloured, wonderful clothes, and I'm trying to explain to her that there is a deeming provision in the Migration Act, and English is hardly her first language, and she was completely mystified, and she said, but I I was there in Brisbane. He was born in Brisbane. I know he was born in Brisbane. I said, I'm sorry, but the law says it's a fiction, but the law says he entered Australia by sea without a visa. Okay, well, in that sad case, I had to give her a big hug. I was in tears, she was in tears. I got on the plane, came back through Perth and back to Sydney again. And I, a few days later, switched on to Sean McAuliffe's marvellous program, Mad as Hell. And he did what Sean McAuliffe does so brilliantly. He had a picture of this healthy baby boy, baby Feroz, and he said, how dare baby Feroz hide in his mother's womb for 9 months to jump the queue and claim Australian citizenship. Well, I think in about a 10-second comedy routine, he did far more than I could ever do. But thank you all for listening to me tonight, and thank you for your support.
Gillian doesn't get a standing ovation every talk she gives. But that was so inspiring and stimulating, and with some sad moments, but it just rouses us all to feel like we can do something. So now it's time for a very exciting part, the Australian Activist of the Year Award. And this year we're giving it to 2 people together, or 2 groups. We're giving it to Annie Keir from Lock the Gate and to the Knitting Nannas. So let me tell you a little bit about Annie Keir. Her first experience of people power was born during the 70s and 80s, when she experienced the excitement of people working together to stop the nuclear escalation. She learned her techniques from scholars and practitioners of non-violent resistance. So I wonder if Gandhi was one of them. In one of her career jobs in population health, Annie studied how whole populations change, how they can adopt new behaviours, and the theory of self-organised networks. Using this knowledge, she helped form Sustain Northern Rivers, a collaboration of regional organisations acting on climate change. Annie then threw herself into the Northern Rivers campaign against coal seam gas fields as part of the capacity building team whose goal was scaling up the movement. She co-developed a process of grassroots democracy called gas field free communities. And after many door-to-door surveys, communities unilaterally declared their district gas field free, as we've just seen, marking their territory with signs to show they would protect the land that they love. There are 147 self-declared communities in the Northern Rivers, and the average survey response was 95%, saying yes to gas field free. This reached across every political affiliation, and this grassroots democracy process contributed to mass movement dynamics, as evident in the Bentley blockade that we all saw. How many people went to Bentley at some point? Yes, look at that. All right. In late 2012, Annie started working as National Community Engagement Coordinator for Lock the Gate, and she travelled to many frontline communities. Her role was to build local campaigners and help them build their movements and their capacity into an ongoing evolution of mining-free communities. There are now 460 gas field-free or coal-free communities in Australia. 460, that's great. She has strong faith in collective intelligence. Considering the present threats to our life support systems and to democracy, she believes we need to deepen social movement know-how so that a great many of us hold it and strengthen it together. So let's welcome onto the stage Annie Keir. A wonderful check to give Annie, which is going to be Bernie, would you like to say some words? Thank you.
Thank you, everyone. That was so beautifully warm. Thank you, Gillian, for that wonderful address. It was so inspiring and stimulating. And thank you, Ngara Institute, for this incredible experience. And I've had the privilege to work alongside the most remarkable campaigners. I'm in awe of their skills, commitment and altruism, and some of those campaigners are in this room. So if you have been involved in the years of the campaign to get a gas-fuel-free Northern Rivers, get rid of those 14 gas licences that covered our region from the top to the bottom, can you please stand? If you've been involved in that. Campaigners in this room. Being an obsessed campaigner can be hard on relationships, and my partner Andrea Hart will possibly be mortified just at this point, but truly we are a team, and Andrea, compassionate defender of life forms, has enabled everything. The good fortune to work alongside the gutsiest community activists you would ever wish to know. People who defend what they love with grit and creativity. People of every political affiliation across the country. And it feels a bit strange to receive an award when part of such a grassroots movement. And I recently shared this with Shay Dougal, a courageous woman who has lived the nightmare of the gas field in the Darling Downs. And Shay, with a great big laugh, said, "Well, Annie, you'll just have to take one for the team." So I invite you, in your imagination, to hear Shay, with her big laugh, walk in to join us here. And can you just squeeze up a bit, because Daniel Tapp's coming in with the top-end station owners from over there, and they're on horses. Oh, and the Alice Springs mob are here, and they've always got those camels with them, you know. Can we squeeze up for the Fremantle activists, for the Kingaroy farmers, for Nancy McDinney and the Borroloola clans, and those big-hearted leaders of Australia's gas-fuel-free and coal-free communities? These entrances could go on and on. So many people working together to get good wins around the country, and the reciting of their wins could take a long time too. In our diversity, we share something. Deep inside, we know it's not right for people near Ackland coal mine to ingest lead every time they have a cup of tea. Or that Borroloola people should mourn the loss of their river and their fish, poisoned by Glencore. Or that George Bender should have felt so overwhelmed by the relentless pressure from the gas giants that he took his own life. We know the system's rigged, that huge donations from coal and gas giants drive policy. We saw the $950,000 donation that New Hope Coal's parent company made to the LNP, just before Campbell Newman did a backflip on his promise that there would be no expansion of New Hope's Ackland mine. We know this rigged system is dangerous for our aquifers, farmlands and communities, for the methane plumes that rise above fracking gas fields, for the life support system of our climate, for the harm it does to democracy. But what I want to say is this. Non-violent movements have given us so much. Human rights won, the vote. In this region, a gas-fuel-free Northern Rivers. Non-violent social movements work. There's a body of knowledge about it. If I was to distill the secret sauce of Lock the Gate, I would say this. A movement is turbulent and generative. A campaign is tight and focused, and we need both. The people we invited into this room in our imaginations with their tenacious campaign work and their camel creativity are connected face-to-face in decentralised networks. Thus flourishes their relentlessness and their resilience. Lock the Gate is able to convert this community power to political power. Turbulent movement, tight campaign. We need both. In the regions, the alliances tend to have a good shape, a core for political strategy, and round that a sphere pulsing with the dynamism of people in face-to-face groups. And round that, a circle of supporters who can be called on at special times, like to phone the minister on a particular day. I've been thinking about the shape of social movements. We've known about the climate threat for a long, long time now. For so many years, why did we fail to grow a movement of sufficient power to shift the politics? It's as if, for a while there, our culture lost social movement know-how. There is recognition that campaigns had the wrong shape. Yes, they had campaign focus, and then an outer circle of supporters disconnected from each other on a database. But to win, we need the active middle sphere, the energetic people with their sleeves rolled up, the dynamism generated in face-to-face groups, collective intelligence. Some great new campaigns in Australia embody this. In all of this, I've really started to think about Facebook. It's incredibly useful for mobilising the supporter base. But does it also trap populations in a pernicious illusion, seduced by the ease of clicking on petitions, the impression that, as we share posts in an echo chamber, we are active in a movement? Before Facebook, when we wanted change, we formed groups. Problem, form a group. Didn't like the group, form another group. Face to face. There's something going on here besides the secret source of winning, and that's well-being from connectedness. If we had some kind of meter that could measure this incredible quality of well-being from connectedness, it would probably start doing loop-the-loops as you approach the Nannas in this room. Without the juice, without the comradeship of face-to-face groups, is there a risk for people whose main contact with a movement is to be on the receiving end of a depressing Facebook feed? Yes, we use Facebook, but above all, we need face. Lots of it. Not just face-to-face groups, but face-to-face conversations in community. If you want to win, above all, less Facebook, more face. I see people in this room who embody this, and all the people who piled into this room at the beginning in our imagination with their local groups and their door-to-door work and their dogged pressure on the power holders embody this. All power to them, less Facebook, more face.
Yes, that's quite a powerful speech from a local ear. Thank you. So our second Activist of the Year award goes to our beloved knitting Nannas for all their work and perseverance stopping coal seam gas. And they were established in the Northern Rivers in 2012, and it started in response to a growing awareness of the exploration for coal seam gas that was happening on prime agricultural land. The Nannas used knitting as a tool for non-violent political activism. I'm sure you will have seen them around in their yellow and black outfits, bearing witness to acts of stupidity and greed, and doing their best to save our land and water for future generations. So we're delighted to welcome 80 of the original Nannas to the stage tonight, including Claire Twomley and Linda Scott, who will be accepting the award on behalf of the other Nannas and poppies here tonight, and all the other Nannas in many other regions around Australia. So please give an enormous round of applause and welcome on stage the knitting Nannas.
Hello, it's good to see you all here. The Knitting Nannas want to thank Ngara Institute for the beautiful award. I've lost it already. It is so great for us Nannas who came together in 2012 to receive this acknowledgement of our work. It's been great for us to hear Gillian Triggs speak. She's been an inspiration to us for some time. Oops, I forgot. I want to acknowledge too the traditional owners of the land, the Bundjalung people, and in a way apologise for the mess that we've made of their land, and hope that their elders past, present and future are happy to work with us to try to show us the way to cleaning up our mess. I'd like to congratulate Annie Kia too for her award on the gas bill-free communities. Our paths have crossed many times over the last 6 years, and she's a real pleasure to work with. Thanks too to the Poppies, partners, kids and kiddies who have gone without cuddles and chocolate cake, who find themselves on the receiving end of too many black and yellow scarves, beanies, gloves and socks. But my biggest thanks go to these gorgeous women. Gorgeous, I've got to look this way, cuddly, valiant women here and in the audience as well, and those around Australia and overseas. Op shops around the country are deluged by a plague of Nannas raiding yellow and black clothing, handbags and jewellery. Every knitting becomes a fashion parade as we compare our newest treasures. Every gas filled finds its op shops raided. So the idea of knitting in yellow and black came from the Lock the Gate signs. By the way, when I say knitting, it's just an umbrella term for all forms of craft. We're not crochetist at all. So, with the colours, you can see a posse of Nannas a mile away. Yellow and black, as well as we heard earlier being the colour of sunshine and hope, are also the colour of danger, so if you think of road signs and wasps. And of course, we're very inclusive. You don't have to knit, you don't have to be a Nana to come and join us. The founding group, some of who are here with me tonight and others who couldn't make it, were brought together by the threat of CSG mining in the Northern Rivers. We had a momentous rally and march in Lismore, 7,000 people in an area with a population of about 50,000, I believe. And so we set up working groups after that. We met in the NVDA, the Non-Violent Direct Action Group, where we were trained in lots of different ways of protesting staunchly but without violence. Around about the same time, Linda here went on a bus tour around the well sites from Megasco Gas Company. The next day she bundled me into her car and took me on the same journey. From that day, the Knitting Nannas was formed. So in the older women in the NVDA were also looking for a meaningful way to join in the action. On Thursdays we would take I can't read my own writing, this is dreadful. A handful of women would go out to various sites, see what was going on, sit there and knit. Not many people realised that we were initially a guerrilla surveillance group. We took our netting, folding chairs and thermoses out to scope out the works and the workers. You can imagine Lindy and I sitting outside a field about 10 miles north of Casino, which used to be the beef capital of Australia before Toowoomba took it over, looking very innocent while the, what do we call them, not bumblebees, the workers anyway, in their bright shirts, the fireflies, were looking at us and scratching their heads. So there we were having picnics. We would go to a different couple of sites each week, have our little picnic, and we would knock the gate. We would tie a little yellow triangle across the gate or across pieces of machinery to show that we'd been there. We started knitting in Thomas George, our State Member of Parliament, who didn't really have much of a sense of humour. He got quite cross with us, and he has said words that I was quite surprised to come out of someone who is called honourable. And we knitted outside the front of Metgasco's offices in Casino. None of these people were happy. We've been called all sorts of witches and bitches. We've been, cars have sprayed gravel at us. We've been spat at. We've been told to show our tits, and we've been told to get something or other job, which is, you know, quite interesting. Threatened to be run over.
And shot at.
And shot at. There's so much in the last 6 years that I can't remember each bit. So, for the last 6 years, the Lismore group, the founding group, have knitted in either Thomas George or our federal member of Parliament, Kevin Hogan, every Thursday. The only Thursday we missed one Thursday, and that was last year's devastating flood where the Wilson River went over the levee banks, and Lismore itself was just turned into a lake. Thank you. No, it was a lot scarier than a lake. It's not scary. So now Nana loops around Australia, those in the UK, and we have one in the United States, generally adopt the pattern of finding a place to knit in once a week and do it again and again and again. And so we sit and we chat and we knit and we plot. You have knitting, crocheting, etc. is just such a brilliant way to come up with wicked ideas. While the hands are busy, the mind works and the mouth never stops. I love you too, George. In August 2012, the Nannas up here on stage went on the Bridging the Divide tour, which is organised from Brisbane and takes you out to gas fields and coal mines in south-western Queensland. We were stunned, to say the least. Lethargic kiddies with big black rings under their eyes, with noses bleeding, ears bleeding, absolutely no energy. Kids who should be bopping around, annoying people, you know, wanting cake, wanting this, wanting that, just lying, you know. leaning on their parents. Their parents, some of the parents have had headaches for years without cessation. We saw towns taken over. Annie was talking about Auckland. Farms destroyed, water poisoned, stock poisoned, families broken up, suicides because of this industry. The families couldn't drink the water, the bore water, because, well, they couldn't bathe in bore water, it burnt their skin. The water they collected from their roofs couldn't be drunk either because of the airborne pollution. They had to truck water in at enormous cost from cities. It's really hard to convey those experiences. Those of us who were there on the bus for 3 days also experienced terrible headaches and nosebleeds. We were only there for 3 days. But we wouldn't be here tonight without those experiences. When we talk to people about our activities, when they ask us, don't we drive or what do we use on our barbecue, we have that strong personal experience and just the strength behind it to convey what we need to. Our last 2 conferences have been in Gasfields, Narrabri and Chinchilla, and our next one's going to be in the coal port of Newcastle. So every new Nana gets to go on a tour of a gas field or a coal mine if, you know, we make it available to everyone. The Knitting Nanas call ourselves a disorganisation. Passionate women form loops, choose the appropriate targets and buy yellow yarn, arm ourselves with our tools of trade and get to work. Our small group here has given birth to over 40 loops here and overseas. Because we're a disorganisation, we don't have registration, so we don't know how many nanas there are. We don't even know how many nanas there are in the Lismore group. We were counting each other just now because we heard there were 8 of us and we could only find 7. But we made the decision not to incorporate because it gives us the freedom to tiptoe along that fine line between law and cheekiness. We work as autonomous loops who are self-organised, but we support each other. The only thing we are answerable to is each other and our manifesto, which I don't have time to read to you tonight. But one thing we make really strong is that we are not party political. We annoy all politicians equally. I did think we had a politician in the front row. I can't see her at the moment. Maybe she couldn't make it. But take it as being annoyed. Probably time to wind up now. I've gone on too long. So, we do. Nanas tend to babble a bit. So now we don't just fight coal seam gas. We brought in fighting against certain coal mines. There's a group in Victoria and Tasmania targeting old growth forests. There's people fighting shale mining, Northern Territory pipeline. The way we work suits everything. As Gillian and Triggs said earlier, the anti-protest laws in New South Wales are absolutely atrocious. A lot of the nanas here have locked on, which means we have locked ourselves to a gate, to a piece of mining equipment, to each other to stop things from happening. When we first started, the maximum fine was $500. It leapt to $5,500 plus, or maybe instead of 7 months in prison. And now we have the new laws that Gillian was talking about, which can sort of get us into the 11 grand range. So, you know, that's your inheritance as kiddies. Gone. You can't stop a bunch of sweet little old ladies with determination in their eyes, love in their hearts, and very sharp sticks in their hands. We're here to save the land, air and water for the kiddies.
Yesterday, we discovered that the Enova community supporter sponsorship aspect of Enova, our favourite energy power company here locally, has donated $1,000 to Ngara. So we're delighted to be able to give an extra $250 to the Knitting Nannas and $250 extra to Annie. Thank you so much, Enova. I'd just like to read out a little bit that came from Enova. And they said that Ngara, as the activist think tank, is working to develop a path to a different, more livable, sustainable future than neoliberalism would take us to. In this region, we have the power to do things differently. We can demonstrate and practically model for others how our future can be different. We have the wonderful activists we are celebrating tonight who bring our communities together and help us stop those things that we must stop. We have the farmers markets, community gardens, the developing collaborative approaches to show us we can meet our own food needs in sustainable, community-based ways without supporting big business. And we have our own Enova Community Energy, working with Zeb and Quorum to show that if we pull together as a community, we can literally take control of our own power. The community can have its own retailer, generation and storage. We can meet our own energy needs sustainably, keep the millions of dollars that now go to the big corporates when we pay our energy bills here, for community purposes, and move progressively to a more democratic, decentralized and distributed energy system. Enova came into being as a result of the work of our activists here tonight. It grew out of Bentley. And they moved us to all stop a destructive and unsustainable approach to meeting our energy needs. And Enova was then developed to show that we can meet our energy needs differently through our own efforts. So if you haven't already joined Enova, please do. With the whole community behind us, we can create sustainable change. So thank you to the community support sponsorship section of ANOVA. And I would just have one last check to give, and of course it is to Gillian and to her favourite charity or cause. But I'd just like to say, in case you're wondering what she's doing now. So Professor Triggs is now the new chair of something called Justice Connect. And it's a non-profit organisation dedicated to connecting people who've been locked out of the justice system. So they give free legal help. These people include those experiencing homelessness, elder abuse, family violence, and financial exploration. She's also the Vice-Chancellor's Fellow at the University of Melbourne and Vice President of the Asian Development Bank Tribunal. And I'd also like to add just a little bit to what Gillian said, that I don't really, just to mention about the children, that there is currently 7 children in mainland immigration detention centres and 136 children on Ngara.
Wow.
40 of those children were, as Gillian said, born on Nauru and have never known a happy, carefree childhood. They've lived in these mouldy tents, behind wire and surrounded by guards. Some families, as you may have heard, have recently been allowed to go to the USA, but many of the children there have actually grown up to the point where they have now become what's called indefinitely detained young adults. So,
What shame.
one last thing, she is author of many books and articles concerned with such things as law and human rights, environmental law, international law, and the law of the sea. But her latest book is called Speaking Up, and how topical that is for tonight. And it'll be published by the Melbourne University Press in October this year. So Gillian, would you like to say a little bit about Back to Back, the charity cause that Gillian has chosen to give her $100 check to?
Well, thank you very much. I really do support this group called, it's not a very good name, I'm afraid, it's called Back to Back Theatre, but what it is a theatre group that started in Geelong. It travelled all over the world, and the actors and the playwrights all have an intellectual disability, and it's quite remarkable what they do, their perception of life. They produce films and they've won all sorts of awards in Europe, but they need a lot of support. But it's quite uplifting to see these young people with some intellectual disability being able to express their own thoughts using theatre. So thank you very much. This will go.
So now we're excited. We're going to have a Q&A.
And I have a question for Gillian. You said refugee policy at present was binary. What's your refugee policy for the boat people?
It's a fair question, and I'd say that people who stop me in the street, very fair people, say we must defend our territory, we must defend national security, we must stop deaths at sea. If holding people in detention long term is the price we pay, then so be it. A lot of people ask me that question, and they're very fair-minded people. My answer to it is that, of course, as a sovereign nation, we must regulate and manage those who enter our country. Every country in the world has a right to defend their borders against invasion, but in some cases we're seeing that in Europe. But in our case, we have a right to manage the way in which people come to our country. I say yes, we can do that, but we can break these people smugglers model. We can stop the boats even. But I think we should be rescuing people at sea, and we should be working regionally with our neighbours to establish possibly offshore processing. There's nothing as such wrong with offshore processing. The point is that people should have their health checks and security checks and criminal checks done, their papers checked, and then we work within the region to find durable solutions. But my key point is that we can do those things and protect our sovereignty and borders but we can do it in a way which responds humanely to the people who are currently within Australia's jurisdiction. And that includes Nannas and Nauru, because we're paying for them and we effectively control it, certainly as far as the law is concerned. So I would like us to turn some of this thinking around, that we look at pathways to protection with our neighbours, Indonesia, with Malaysia, Vietnam, Sri Lanka. We talk to these countries. Myanmar, why are we providing military equipment to Myanmar and not demanding that they comply with international law? We have 800,000 stateless Rohingya fleeing to one of the poorest countries in the world, Bangladesh. We should be working diplomatically with all of these countries to see if we can find a way through the problem. And there are root problems, one of them being refusing citizenship to all Rohingya. That is one of the causes. As I said, it's binary. We don't need to hold, 136 children on Nauru in order to break people smuggling rings and to save lives at sea. We can bring those children back to Australia. My view would be to bring these children and the young men and the families back to Australia, that we have a proper legal process to determine if they meet the refugee standard, and 85% of those assessed so far do, and that we then move to finding durable settlements. Not necessarily in Australia. I think New Zealand has offered 150 a year. If we'd accepted that offer some years ago, we would have cleared Nannas Island out by now. So I think that there are ways of doing this that don't rely on this binary, but yet politicians promote this constantly. And I think that we can achieve proper national objectives while also acting in a compassionate way to those people within Australia. And just finally, and I know I've spoken a long time, just finally, we have nearly 30,000 people living in the Australian community at the moment whose claims to refugee status we haven't assessed. And they're being picked up by faith-based groups, charity groups, NGOs, civil groups all over the country, and many of them rural Australians, refugees, wrapping around these people and giving them housing and comfort and support for their children in schools and getting them into employment. I think we can do that well in Australia. But of course we don't want to encourage smuggling, but we have to accept that people that reach our shores have a right to claim asylum. We put a freeze on claiming those asylum seeker claims for about 5 years, and they were only allowed to make an application in October last year. That's why we've got this legacy. The government talks about the legacy problem as being a problem of the Labour Party, but we've actually had the last 5 or 6 years of policy imposed by the current government, and we've not assessed those claims. So there's a lot to answer to your question, but I do believe that we can develop a policy which both meets our sovereign needs to defend our borders and to defend us against prospective terrorism. But equally, we can act in a humane and law-abiding way and compassionate way to those people that are currently within our jurisdiction.
You mentioned the Mullumbimby Charter. It's possible we could make some movement on that tonight. I am wondering if you have some advice about how we could do that.
Well, look, it's partly serious. I think it's quite serious, actually. This is a very special part of Australia. Why not establish an Ngara subgroup or a group of the community here? I don't care what you call it, but it should be, Mullumbimby. Why not put some basic ideas: protection of the rights of the child, the rights to protest in an orderly and non-violent way. Some very simple ideas on one page, and then say, we're standing up for this, what about the rest of Australia? It's not a difficult thing to do.
What do you think would be a simple strategy for first steps of getting enough people knitting or agreeing that this is something that we need to do as a community and a nation?
Well, thank you. I mean, one does have to be practical. I mean, it's fine for me as a lawyer to be sort of coming up with this idea. It's hardly a new idea, of course. But the real capacity to give it effect is going to be communities insisting that our politicians take this up seriously. And I think that if we had a simple document with some simple ideas in it that people could readily comprehend, with some examples of where we've failed and where the risks are, it needn't be a difficult thing to draft. then I think we could use community networks to start building across Australia. I've been doing a lot of speaking over the last 6 years, particularly the last 6 months, all over Australia, in small country towns, faith-based groups, charity groups, government bodies. I'm doing something in Canberra in a couple of weeks, or a little while, for Emily's List, to get more women elected into Parliament. But speaking on a non-political level, I think we could join communities together to start to get the idea moving. But it means more people need to speak up. I need more people to say, well, you know, the knitting Nannas, perhaps you could hand out the charter sometimes. You could say, we're thinking too, we think, which I think is wonderful. And so there are ways of doing it. And I haven't been a social activist. I'm actually a conservative black little lawyer, believe it or not. The government doesn't believe it. But I think that we now need, I've tried everything. I've tried Senate estimates, I've tried ministers' offices, I've tried grand reports to Parliament, we've tried litigation to the High Court, we've tried everything. I've now come back to the community to say, the strength lies, as was said, the strength lies with you in the end. And I think if we can get these simple ideas to Australians who have act in good faith, and most do, I think the fair go is a great idea. We all get a fair go, and Australians are pretty quick to work out what a fair go is. You don't need me to say it's section something or other of an act. We know it when we see it. Why not try to get the community and the public environment? Maybe our mayors could come together. Maybe we could get working groups to work across boundaries and to talk about it. So I think we can do it, but I think it needs social mobility, and it needs focus, as you mentioned, to make this work. Sometimes you need that iconic photograph, that iconic vision. The picture of that Indigenous youth in a steel restraint chair with a hood over his head in Don Day. We'd reported on that situation 2 years before, to no effect. CCTV footage and four corners, and the Prime Minister's on the phone the following day saying, should we have a royal commission? Maybe I'm a great admirer of those people who take photographs, who spread the photographs around in social media, or the filmmakers who I think Amada's new film, The Julia Burnside's in with a wonderful filmmaker, is coming here in the next couple of weeks, called Border Politics. These have huge impacts politically, so let's use everything we have to make a reasoned, evidence-based, fact-based argument that we now need basic principles of the common law to be articulated in a charter. So let's think about the various ways we can do it, even if it's putting a little yellow knitted piece on a piece of farm equipment. What a powerful statement. And good luck to you. I think it's a brilliant thing that you're doing. And I found you very helpful, in particular in Tasmania. The knitting Nannas there helping children held in Pottville. That's where I first got to know you. But I think you're wonderful, and I think we can do more of this in the social environment.
2001 happens to be the year that coincides with 9/11, and since then, the war on terror and the use of fear as a piece of social engineering and the use of wedge politics in Australian governance has shut down meaningful opposition. Can you speak to that and give us any ideas you have for what can possibly be done about it? Thank you.
Well, I agree with you that in particular, as I said, if you draw a line in history, from 2001 we've seen the use of fear to promote government policies and government laws that have breached our rights. But also there's now an Islamic register of Islamic incidents, and we've seen a 20% rise in anti-Islamic public behaviour. And we've seen a 20% rise in incidents against the Jewish communities in Australia. These are very, very troubling outcomes of a political environment where our politicians license us through social media and other mechanisms to say things that were unthinkable 20 years ago. Absolutely unthinkable. I thought we'd never do this again. And yet now we are in numbers that are really troubling. I don't think I can say very much more in response to your question, other than to say that just keep an eye out for every speech and every nuance in the media that seems to link fear and national security with ever more intolerance, racism, jingoistic policies that I think are damaging the Australia that our forebears fought for, and indeed, you know, that we fought for in both the Second World Wars. These were not the principles. We did not fight wars in order to end up with a society in the 21st century where we have rising levels of racist and nationalistic policies. This is not Australia, and I think that we need to call out the politicians when they try to threaten us with fear. We need to stand up and speak up against it. Thank you.
So we do actually have, we will, just to one more question, because Ian Cohen is in the back there.
You mentioned the plight of the Rohingya refugees, and I'm just wondering, in your position, and I know for myself, what I see in a society that needs to protect its most vulnerable, that someone like Aung San Suu Kyi could somehow fail. And am I right? I know it's disappointed many activists in Australia the way things are going, or is she just so hamstrung by a ruthless military that there's nothing she can do? Do you have any ideas or insights into the situation that's occurring there?
Yes, I don't have any insights into her motivation. It looks as though she is hamstrung by the military leaders of the country, and that she's pretty much forced into this sort of Buddhist nationalist view that's taken by the military leaders of Burma, Myanmar. It may be much worse than that, but I think it's hugely disappointing that this woman that we have respected and admired for so many decades and supported with money and with political support for so long should have underplayed and failed to acknowledge the deliberate murder, rape and burning of villages of Rohingya, peoples who've been living in for decades in Myanmar and who've been denied citizenship. And the great tragedy is that these people come to Australia when they do. They're held in immigration detention, they can't be sent anywhere because no state will receive them, and they end up for years in detention centres with no citizenship, with no capacity to make a move in any direction, and no one will support them. But again, and it's typical globally, it's the poorest country like Bangladesh that's actually housing and feeding these people and concerned about their futures. It's very disappointing. I'm very disappointed in the Australian government that we continue to give support to the Myanmar government and that we've not used what political muscle we've got in the region to demand that they meet the human rights needs and expectations of these peoples. But it's a tragic, tragic situation of huge dimensions. And why are we surprised that some of these people have managed to find their way into Australian waters? I think all compassion and humanity should be to support them and to help them get back on their feet. And as we know, if everything I've said tonight is irrelevant and we concentrated only on the money, $1 million a year is going into offshore processing, $1 billion a year is going into offshore processing, $1 billion at least into stopping boats. Couldn't we divert some of those funds to bringing these people onshore, helping them into the community, getting them into jobs? We know that in the end they are fruitful members of the community, and indeed research by Deloitte's economics say refugees are in fact far more effective entrepreneurs than other migration groups, and they pay more tax. Well, that's the end of the argument. It's an economic one. So nothing I've said tonight's relevant.